It was now successful, but it was a little frustrating to get in here and try to get ahead of things. Have vision, that's your day.
Best laid plans.
That's laid plans. Nice. Good morning. This is Senate Judiciary, Friday, January 26, 2024. And the first item on our agenda is the confirmation of superior judges. We heard testimony from 2 weeks ago, and last week we heard from a constituent concerned about Judge Tebow. And the judge is here in person this morning to give us his side of the story. And then we will be voting on 5 of the 6. We already voted on Judge Battles because Senator Hashim had to recuse himself, so we figured we'd do both.
Good morning, everyone.
Go ahead.
Good morning, everyone. For the record, Roy Tebow, Superior Court Judge and nominee at this point for consideration for confirmation. I'll start by saying with the conversation this morning, I just want to disclaim that while I can write orders, I have no power over either the weather or the vision system. So I can't help with any of the current predicaments here in Montpelier this morning. With that being said, I want to just briefly address the concerns of Mr. Whitaker, who appeared last week. Mr. Whitaker's cases were 2 of approximately 8,000 cases that flowed through the Washington County State's Attorney's Office during my 5.5 years as the state's attorney, or 5+ years as state's attorney. In any event, they were handled by deputies. I had minimal involvement on, I believe, a motion to quash a subpoena that was filed by a private entity in Montpelier, where the state had to make appearance and some argument. Ultimately, my conclusion is this: the system worked as it was intended to. The investigation wasn't just based upon law enforcement reports; rather, it was based upon collection of sworn statements from community members. Those community members felt that a crime had occurred. I don't have access any longer to the state's attorney files or the internal notes, but my recollection was there were 6 to 7 complainants. Only 2 or 3 charges resulted because there was discretion applied to what constituted a potential criminal offense versus those that were just a citizen dispute or other things that did not rise to a criminal level. Throughout the course of the proceedings, Mr. Whitaker exercised his rights. He filed a motion to dismiss. He prevailed in dismissing the stalking charge. That being said, the complaining witness in that case did submit a sworn statement that outlined the essential elements. The court had previously found probable cause for that offense. However, on balance, and hearing from her and reviewing her statement in more detail, the court decided that the elements couldn't be met. The other charges and offenses did proceed to a trial, which resulted in acquittal on one count and a hung jury on the other, meaning at the end of the day, there were at least some members of the jury of the peer who felt that there was proof beyond a reasonable doubt that that offense had been committed. Ultimately, the cases were dismissed by my successor. She declined to relitigate the case and went to trial, and there's a separate matter involving an alleged disruption of a public meeting in the city council meeting at Montpelier that she also dismissed. And unfortunately, I don't have insight as to how or why. Mr. Whitaker raised one other important issue, which was this be appearing on his record. I would note that based upon this committee's work and leadership, there is a basis upon which individuals can have immediate expungement of non-convictions. So the court process will catch up and eventually expunge those automatically, but he's certainly entitled to file a petition and seek expungement of both dockets sooner rather than later. So I don't have much more to offer than that because I didn't directly handle the cases. They were litigated by junior deputies in the office. So while my office had, in the role of the state's attorney, I had oversight of all actions, these were not cases that I handled personally during the substantive portions of litigation.
Thank you. Senator Biles.
Thank you, Judge Tebow, for being here. One of the things that came up in Mr. Whitaker's testimony, and I'm sure that you watched it, was a sense of not fairly working with police. And so I guess I wonder, in your role as a judge, what your view is on police oversight and ensuring that that process is fair and transparent.
So the judiciary has very limited direct control over that. That being said, I can speak more to my record as a state's attorney. I was a leader within the department in trying to draft and have a consistent approach to dealing with law enforcement misconduct. And what that entailed. I think the committee has heard prior testimony about Brady Gigley letters, things of that nature. And ensuring that there is fair response, fair discovery, and disclosure of issues in law enforcement is important. And as a judge, I think the key point is making sure that the regulation discovery requires full and appropriate disclosures by the state in a timely manner that allows criminal defendants to process and analyze that information before they make key decisions in the case of whether to accept a plea agreement or whether to go to trial, or the risks of doing so. And officer credibility, of course, is an issue. It can always be an issue, even in the absence of formal documentation or letter. And it's an important question for jurors to consider. We have standard jury instructions that allow for jurors to consider law enforcement testimony akin to any witness, which is they're not afforded any additional credibility automatically based on status. Rather, it's all of the circumstances and all the evidence must be considered when weighing whether they're credible or not.
Thank you.
I'm not going to comment on Mr. Whitaker or yourself, Judge, but just make a general comment that I think we see, particularly on the local level, more and more angry discourse that leads people to want some kind of action, whether it be police, arrest, whatever. And I think we need to be more concerned about that particular thing that's happening on our school boards, our local select boards. And I think it's going to be much more difficult to find people willing, it already is somewhat difficult to find people to serve on a school board. I can't tell you how many of our school board elections are uncontested, or they have to find someone and appoint somebody after the election because there's nobody who stood up to run. And I think you're going to see more and more of that as this discourse gets more and more heated. And I don't know how to really deal with it, but I served on a local select board. It was chair for 4 years and member for 7 years. And I didn't confront that in the 80s when I served. It was, there was always a few who were upset about taxes or whatever, and you understood that. But this personalizing so-called seemingly innocent efforts by a select board member to explain something, and then it becomes this horrid argument. But I think it's something we all have to be aware of. We have a little more control in the State House because we have police readily available. But I know in my local school boards, they don't have any police there. They don't have an opportunity to have somebody removed if necessary. But anyway, there's nothing to do with you necessarily, but it is a problem, particularly on the local level. So with that, are there any other questions of the judge? Judge, thanks so much for dropping by.
Thank you so much for having me. Wonderful to see all of you again.
You're welcome to stay for the votes on all the judges, and you can report back to them why they didn't make it.
I had the pleasure of sitting with Judge Battles yesterday. He's very excited to be the first one out of the gate.
So why don't we take in order of whatever you've got there and let us know who's first, and then we'll go around the room. After we have a discussion, you can call the roll.
Of course. So first up.
Oh, do you want to let Senator, I can let Phil tell the vote.
You can also run down to his office with it.
I think I'll just send him a note, text. No, wonderful, we can send text today. Well, just sent you a text. We're ready to vote on the judges. That was almost immediate. I don't even think you got the text yet.
Well, I heard the call till half of it, so I
My favorite Marshall.
Well, that's an old one.
Yeah, old, probably never saw that.
I have not.
It's the weird, other than Mr. Ed, it's like the weirdest sitcom idea ever. Like, there's just a Martian that lives in this
Right.
guy's house.
I mean, the eighties had Alf.
But he had
Yeah.
rabbit ears. This was the days when we had rabbit ears for our TVs, for the antenna. And he had rabbit ears
Hear your thoughts.
that could go up and down depending upon who was arriving. Anyhow, my favorite Martian. So
He survived.
I'm just about to start voting on the judges, so who's the first judge?
So first was gonna be Judge Susan McManus.
Judge Susan McManus from Manchester, who's here. She's, talked with her, and was there any discussion of Judge McManus?
Hard to remember who's who at this point.
Well, she was she worked for a defense firm with her husband and David Silver and others. And they kind of monopolized the criminal defense group. So she went to the public defender's office.
Gotcha.
Bennington County and Wyndham, I believe she worked in Wyndham also. Is there any further discussion on Judge McManus? I would move that we report favorably the confirmation of Judge McManus.
All right.
Call the roll.
Yep, so, Senator Booth,
Yes.
Senator Norris,
Yes.
Senator Rohowski,
Yes.
Senator Sheep,
Yes.
and Senator Sears.
Yes, and I'll be happy to report Judge McManus, since I know her and her husband.
All right. Next up is Judge Alexander Burke.
Judge Burke is from Arlington. It's a rarity. I don't believe there's been a judge from Arlington since Arthur O'Day. And Arthur O'Day was a good judge in my opinion, but he's one of the only judges that ever lost retention. Back in 1993. Anyway, Al's been a prosecutor with Bennington County State's Attorney. He's been the lead prosecutor, was the lead prosecutor on many of the more serious felony cases, sexual assaults, drug, murder, those types of crimes. Any further discussion on Judge Burke? All right, I would move Judge Burke.
All righty, so Senator Booth,
Yes.
Senator Norris,
Yes.
Senator Rohowski,
Yes.
Senator Sheep,
Yes.
and Senator Sears.
Yes,
And who would like to report that?
I'll report to Judge Burke. I'd like to report my constituents, and I haven't had an opportunity to do that for a
I do have a
while.
few in this.
We haven't had any judges from Bennington County. I think Judge Howard was the last, actually. He's retired. I see him at the grocery store.
Up next, we have Judge Navasparrow.
Judge Navasparrow, I don't.
Navasparrow.
Navasparrow.
I can hand out the interview.
That would be helpful, because I took notes.
Not all.
I mean, I admitted right out of the gate, but it's hard to remember all of them.
Yeah, well, yes, now I remember.
Yes.
I can visualize it.
Senator Rohowski.
I thought I was just having a senior, I thought I was having a senior moment, but you're not allowed them.
Oh, I can't claim senior moments?
No, you can't have them. Trump and I are allowed senior.
The Trumps are with sarcasm.
Yeah. There was an article column yesterday, Watson, Trump, the grumpy man.
Thanks, Tom.
About his
Thank you.
victory speech.
Yeah. He never worries about being uplifting, that's for sure.
Is there any discussion on Judge Sparrow?
I don't see, like, I certainly plan to vote to confirm, but I did find it a little concerning that Judge Sparrow identified that the system is without bias. That definitely gave me pause, given how much discretion there is in sentencing and how much we know there is bias. But I think that perhaps that comes from the more sitting in more administrative and not within the criminal system. And I think that Judge Sparrow held a really open mind and may come to view things differently with a different perspective.
It might, because 95% of her cases were either probate or civil.
Exactly, and that's sort of where I anticipate that sort of sense of like, oh, this is an unbiased system may have come from, and in sitting in criminal court, I'm hoping that there is a shift.
Yeah, she's only had, she had very little juvenile or criminal experience. That can either be a problem or a positive event. Is there any further discussion? Not, I'd entertain a motion to vote favorably.
I'll make that motion.
Senator Sheen has moved that we report favorably Judge Sparrow's replacement of Superior Judge Mello.
All right. Senator Bruce,
Yes.
Senator Norris,
Yes.
Senator Rohowski,
Yes,
Senator Rishi,
Yes.
and Senator Hughes.
Yes.
And who would like to report?
I can do this one. This is a Burlington resident to one of my constituents, unless Senator Ruth, you want to.
I defer.
Okay. I already have a judge, so I don't want to hog the judges.
You already have it.
Yes, Judge Battles is.
Oh, that's right.
My
Yes, you
report.
have Judge Battle. Who's next?
So next would be Judge Rachel Malone, and would anyone like interview packets for Judge Malone?
I'm fine.
I remember.
Owns the comic book shop, right? It's
Mm,
probably the most
Coffee.
important piece. Coffee and comics,
Coffee.
yes. Automatic, yes.
I like coffee.
Senator Sheen has moved to report favorably.
Right, yeah, I guess I did, yeah.
Ben, so Senator Sheen has moved to report favorably to the judge. Is there any further discussion? If you would, please call the roll.
Senator Bruce,
Yes.
Senator Norris,
Yes.
Senator Rohowski,
yes,
Senator Rishi,
Yes.
and Senator Hughes.
Yes.
And who will report this?
I guess that's me.
Yeah. Yeah, you can talk about the comic books.
Yeah, that'll be probably the entire speech.
And last but not least, we have Judge Roy T-Ball.
Well, that's enough then.
I will move that.
Senator Baruch has moved, Judge Tebow reported favorably. Is there any further discussion? I will only mention that my time with State's Attorney Tebow was most helpful in a number of cases, and he was helped with the alleged counsel in a number of cases as well. And for that, until he's confirmed, we can still say our thanks to you for all that help with this committee. He was somewhat helpful when he worked for the Department of State's Attorney.
Not as much.
But then he was less guarded, more guarded, I would say, in his opinions than he was as an individual state's attorney. And I'm forever grateful for his work for the horse bunny.
For the horse bunny?
That was the first time I met him, and it was a horse that had been shot with a bow and arrow in, I believe, somewhere in the Barry area.
Yes.
And the family of Bunny the owners of Bunny, and this young girl, Bunny was her horse. And they came in to, I believe at the time it was a very difficult case because of our animal cruelty laws, and we updated the laws as a result of Bunny. And they had pictures of the horse and everything, and the guy had actually stolen the bow and arrow from the Berry archery dealer. I believe that was and that was more serious than killing a horse at the time. So it was forever known as the money bill.
I remember that case, I don't, remember if I staffed it or not, but I
I
do
think
remember
you
that
did,
issue.
Michelle.
Probably, but at this point, it's starting to blur a little bit.
It was a long time ago when we were all much younger.
Yeah. But are my details correct?
Yes, and that was, at the time, that was a really, important issue in the Berry community, given all the circumstances, the publicity. So I think it was a wake-up call to many at the time about what the penalties were, and that property crimes were dealt with in a more substantial manner than the taking of an animal's life without cause.
Anyhow. You want to call it, you want?
Yeah, of course. Senator Brew?
Yes.
Senator Norris?
Yes.
Senator Bohosky?
Yes.
Senator Ishii?
Yes.
Senator Sears?
Yes, and I thank you. I don't know who wants to report. Senator.
Unless anyone else.
And that concludes your confirmation of the superior judges.
All right, we'll probably have some more appointments. Next Thursday, I'm gonna be out, and we have one bill from Senator Hashim and one bill for Senator Bowski that I hope we can dispose of or deal with rather quickly. One would be to add 2 Superior Court judges. I think Judge Zone is gonna come in with a request for 3, and they often do.
The governor put 2 in his budget.
The governor put 2 in his budget, but I think Judge Zone wants 3, and I think Terry Personnes will want 6 staff, additional staff. So anyway, I'm asking Ben to contact Joint Fiscal to get a fiscal note on the cost to judge both the 2 that were in the bill, as well as the additions that the judge is gonna ask for. And then the second bill would be, the bill that deals with, that Senator Bowski sponsored, which is the one that deals with the rape, the sexual assault cases where someone is in civil court and they're able to use the victim's prior sexual history, or she wore a very short skirt, therefore she should only get 50% of the claim. So that would be, and hopefully we can deal with both of those rather quickly. Obviously, the Judiciary will go to the Appropriations Committee, but I don't know who's against it.
Me
We'll
neither.
probably find somebody.
I wonder what the Defender General's office.
Well, he wouldn't, because
It's to
this
the
is all
civil
civil.
But I just always
In
feel
the
like,
criminal realm, they can't use that.
understood, but I just feel like the
What's the
office
number?
is always against anything that
What number?
Yeah,
reduces
my bill?
the,
It's 220.
I don't know.
But let me
Reduce-
check.
well, there may be some civil attorneys who, I don't know, once they find out about it. Certainly is an unequal footing.
I do know that there are some changes that need to be made in the bill. We kind of rushed to approve it, and my understanding from some trial attorneys is it doesn't actually, the way it's worded, it doesn't quite do what we want it to do.
Okay.
But it's not changes that need to be made because it's It was just worded funny.
Yeah, all right, well, you guys
Yes.
deal with it. I won't be here. I'll be here remotely on Friday.
Oh, no, it's 2/26.
And then
2/26.
sometime the following week or the week after, we'll take up the
Nope, that's not it
second
either.
one bill.
I'll find it.
But I want to be here for that. So, anyhow.
Well, congratulations before we take off.
Thank you very much.
278.
Congratulations.
270.
Thank you for.
I'm good at numbers apparently.
Thank you, Senator Sears. Well, hopefully I'll get to testify again Sunday.
Hopefully,
Take care.
But it'll be
Thank
just
you.
to say, I can't weigh in on policy decisions.
Okay.
Sarah, sure, so Judge Zoney is in the Zoom room now because of confirmations. Do you want to have a little conversation about what we were just speaking about at 58? Or do you want
Yes.
to have him come back
um,
later this morning?
what's his
Or-
availability?
Send me a message real quick.
I'm gonna be very, very quick on this 190 because I think it'll take me 2 minutes and everybody's in agreement on it.
Okay, well, why don't we go over 190 then?
Okay.
And then send a message to Zeb Zone if he's ready. We can hear him before the break.
Today's already
Is that
ready to
okay?
go.
Message received, Senator.
Okay, we'll talk to you shortly after the break.
When he has those headphones on, he looks like a sportscaster. I expect him to start calling
It's true.
color commentary.
All right.
So Ben, did you give them copies of the amendment?
Yep.
Yep.
Super.
Special investigator.
Do you have an extra copy there, hard
I
copy
do.
for me? So for the record, Michelle Childs, Office of Legislative Counsel, and we're taking a look at an amendment to S-190, which you voted out earlier in the week. And I was just wondering, because I didn't see it on the calendar, did you guys just vote it and hold it here, or?
I didn't see it on the, so it would
I
go,
didn't,
well, did somebody take it up to,
who's gonna report it?
Ben, you still have it, right?
Judge
Senator
Norris.
Norris, yeah, as well.
I'm gonna report
I
it.
mean, excuse me, I called you Judge Norris for a second.
I like that.
maybe, didn't get taken up to the secretary's office?
And evidently
I
not.
still have it here, Senator Norris.
Right, I was gonna wait for her amendment.
Ah.
Vetoed by Senator Norris, his own
Okay.
bill.
That's Judge Norris.
Judge Norris.
Gee.
Well, I could take the amendment up with you, I guess.
So I wasn't sure because I didn't see it on the calendar. I wasn't sure who was offering it, but Senator Viejo speaker had asked for it, so I just put it there. I can add everyone's names if you want me to do that. You know, you can't do a committee amendment, and the bill's already been voted.
Well, I
but-
think as long as Senator Norris's name is on it, I'm comfortable. She's the reporter, Senator Bowski. too.
So simply what the bill, what the amendment does is it adds a new section to 190. So we're talking about the hearsay bill and hearsay deposition bill. And there was discussion among some of the witnesses around the recording of interviews of children who are being interviewed by the by the special investigation units. And so what you have here in this amendment is a new section 2A, and we're amending the SIU statute. And you'll see that on page 2, there is a new subsection B that simply says that any interview of a child pursuant to this section shall be electronically recorded. And then I use the definition of electronically recorded that you currently have in statute with regard to custodial interrogations that we've had on the books for a number of years. So when we say electronically recorded, we mean an audio and visual recording, that it's authentic, accurate, unaltered record of the interview. Jen Pullman and Marshall Paul are both on board and support this amendment.
So just a question I'm trying to remember from when we talked about it last. We were talking about two different kinds of input from these witnesses. One was a teacher or someone talked to them in kind of informally at the beginning of the process.
Mhm.
This would be for more deposition type?
This is for the interviews so the special investigation units are required to be involved in these certain types of cases
Yep.
that include the serious bodily injury. So this would only apply to those interviews that are being held there. So
Understood.
not for, like, if it's a teacher's, if that, the rule would still apply, what you have currently for hearsay under there, where
Yeah.
the court is weighing all
Yeah.
the information, trying to determine.
So that wouldn't be covered by the need to be electronically recorded?
Correct.
Okay, great.
Yes, that was the needle
Yeah.
the reason it's not in the bill is because we had to figure out how to thread that exact needle.
Okay.
Okay. Is it simpler to keep it as an amendment since we already voted it out? And so we vote this amendment, and that would both go up on the calendar.
Sure, and I can, if you want me to, I can add everybody's names to the amendment, so it's
Yeah,
essentially a
well,
committee
sure.
amendment. But since you've already voted, you can't,
Unvoted.
yeah.
But Senator Norris will still report the amendment.
Okay, sure, so I'll put his name first, and then I'll put the
Please.
rest of the members, and so I'll just take care of that, and I'll give a copy to Ben as soon as I can.
Should we
update
vote
that.
on this?
Probably.
Yes.
Yeah.
I move that we find this amendment favorable.
Ted, would you please call the roll?
You're on a roll.
It's very funny.
Don't have a record of action plan, so we'll go out shortly, but, the question is to vote for favorably as amended. Senator Norris,
Yes.
Senator Ruth,
Yes?
Senator Bohosky,
Yes.
Senator Hashim,
Yes.
Senator Sears,
Yes.
Shut up.
and we are all set.
The record will note that we did it correctly,
Yes.
that we actually voted on the amendment. All right, thank you, Michelle. That really
Sure.
was quick.
Yes.
So our first bill is out, and hopefully Senator Norris will take it up today. So
I will.
we can have a vote on Wednesday on the floor, unless Senator Baruch wants to hold it off.
I don't know.
Sounds good to me.
So can I just tell you, so on the next
Yeah,
one,
let's talk about,
for,
well, first of all, let's bring Judge Zoning back into the committee.
but can I tell you, I have some language I want to show you for his conversation, and I just sent it to the coffee room. So what I did in just
We're taking up S 258, S 50,
Right,
right?
correct.
Yeah.
So just after you and I were talking, right before the confirmations, I just drafted a really super quick committee amendment, so don't hold me to it. I literally did it in like 5 minutes, but in there I did it. I put in some placeholder language related to ejectment of someone who is not a tenant. And I think Judge Zone is gonna be able to talk to you a little bit about that, and that goes to the issue that Rory said, which is, you know, maybe an avenue is, because we do have a law in the books, but if it's not being used, maybe you expand the number of, the folks who could seek an ejectment, and Rory just kind of threw out there the idea that perhaps you might want to consider allowing a state's attorney to do that. But I wanted you to hear from Judge Zone, because we had a good meeting yesterday with John Gray, who's our landlord tenant attorney, property attorney on, who's new on staff, and talked about all the different things that are currently in statute. So there's the, so when you have a tenant, you go through, who is on the lease, there's a process for expedited serving of notice if someone is engaged in criminal activity, right? And so there's something on the books there, and we were looking at that. But Senator Sears was saying, well, what if someone is not on the lease and they're just staying with someone who is on the lease and you want to get them out? And so there are processes in Title 12 in the court procedure titles with regard to ejectment and detainer. And I think probably what you'll see in this draft is the section having to do with an expedited hearing for ejectment of someone who is not on the lease. And I think that's what hopefully Judge Zone can talk to you a little bit about. I just wrote it and I sent it to the copy room, so it's being printed right now.
I'm just wondering if you eject the person and then they come back, how is that enforced? I'm thinking about the case of the apartment building in Burlington where the testimony was that friends of the person on the lease were dealing out of the apartment. And they couldn't get rid of them and, so I'm wondering if you go through that whole process and it's ruled that they're ejected and then they leave and then the next day they come back, do you literally have to have a police officer?
Could it be contempt of court?
I'm not sure
I don't know.
the enforcement aspects of
Yeah,
it, so
just-
that,
Thinking since we're so short-staffed, it's hard to believe that you wouldn't have the problem of people just, because they're ignoring every piece of civil procedure. Why wouldn't they ignore the order? Because they're not on the lease. They could just say, well, I'm not there, and then show up. And then,
Maybe we need to build in that that's contempt of court.
I think it would also be a logical step for probably any landlord to issue a no trespass order right after the ejectment order is.
right, and these are some things that, we talked about, there's a lot of things that are available, whether you could order, you don't have to go through the ejectment process, you can issue a no trespass order, and then if somebody's in violation of that, then it's a criminal violation under unlawful trespass under Title 13. You can also set conditions of release if they've been picked up for dealing, and then conditions of release say you can't go to the property, and then that's a violation
I
of the
think it needs to
conditions.
be simpler, and there need to be some teeth with it. Whether that's contempt of court or whatever, but we need to let state's attorneys do this.
I'm gonna go run and grab those copies, if that's okay, and
Judge
Sorry,
Zonay,
Judge Zoney, for putting you on the spot so quick. We thought we were gonna do.
while
this
we're
next-
waiting, you might have heard a conversation about next Thursday. I'm not gonna be here, but we would like to have you and, Terry Corsones join us to talk about the two judges that are currently in the budget. And I believe you would like a third, so it'd be total, that's a bill Senator Sheem introduced. And there would be your request is 3 judges and 6 other positions, is that correct?
I thought Terry was asking for 10, but but 6 is better than 0.
Well, we'll be looking for joint fiscal to be able to give us some figures on that. So if you could
Absolutely.
let them, we can request joint fiscal to do an analysis of the request, of your request, as well as the bill's request, for the appropriations committee. So.
We will touch base. Thank you. And I do have to, if it's okay, I did hear your conversation earlier today about my favorite Martian, and as I'm sitting here with my headphones on, all I could think of was coming on and going like this. So
Well, at least you don't have rabbit ears on your.
no rabbit ears. Although, boy, when the names Ray Walston and Bill Bixby are mentioned in 2024, I'm telling you, it brings back some memories.
Yep.
I was more the magician era for Bill Bixby.
Very good. Yeah, and there's a large group in our culture who look at Bill Bixby and think of nothing but the Incredible Hulk, and then I look back and go, wait, he was the Courtship of Eddie's father too. So you can kind of pick your phase of life based upon those shows.
oh, I know that song, I have no idea what the.
He's a one boy cuddly toy.
I have no idea what the rest of what you're talking about is, but I do know that song.
One often wonders how some of
That's
these
the
shows
rumor.
ever get on television.
Yeah. Well, lots of shows about single dads and how great they are. Never shows about single moms.
You know, this.
My 3
sons.
One Day at a Time was actually the first one I can
Yeah.
remember.
Yeah.
And then Alice,
Yeah.
what was that? It was
The waitress
The
Alice?
Waitress Alice.
Yeah, it was called Alice, wasn't it?
Yeah, Alice, okay,
Yeah.
yeah, no, I got the right show. But yeah, I've been watching, ever since Norman Lear died, I've been watching the reruns of All in the Family on
Yeah.
Amazon. And it's hilarious today, as it was then, and many of the things that Archie says
Yeah.
would be something one would expect today, yeah, that's.
that was my dad's favorite show. Like, you couldn't, no one could move in the house while that was on. You had to hear every word of it. He was just such an Archie Bunker fan.
Well, you know, the toilet question
Yeah.
was so unique.
Or the turlet, as he
The
called
toilet, yeah. You know, nowhere else on TV was a toilet ever.
Yeah.
All right, Michelle, how we?
Apparently emails are not going through, so I can't. So Ben's trying it.
Okay.
But I think we can still have the discussion.
Okay,
And
let's-
then we'll keep trying.
Yeah, back to S58 and the evictions and how we deal with those. They're not really, I think we need a better term than eviction because it's removing people who are not leaseholders or are not renting the.
That's ejectment.
And I think your idea about making it an automatic, no trespass.
I think that was Senator Hashim's idea, but
Okay, well, whoever's.
I was just looking quick, in New Jersey, ejectment ends with a lockout by the county sheriff. I don't know. Just another,
But theoretically, wouldn't someone not on the lease already be sort of locked out? So would the sheriff change that, like, how would that work if the tenant is able to stay, but the person who
Well, that's
should have
what I
never
did.
been there?
The tenant, so the tenant, holds a certain degree of property rights for the apartment that they're leasing, and they can invite people into that apartment. So they're not automatically a trespasser with the tenant being the victim of that trespass.
No, I understand the trespass, it was the lockout, because when we use the term sort of lockout by the sheriff, it's usually in relation to an eviction, and it is actually changing the lock, so someone can't get in, and I just don't see how that plays the same way if the person was not really supposed to be there
No,
in the first place.
it's true, and it goes back to my question of, it seems like it's, with this particular group that we're targeting, who are, kind of impervious to the whole civil procedure, or, you see videos of the retail thefts that we're talking about. These people they don't care that there's a security guard blocking their exit. They'll just keep trying to go around because in essence, they're not approaching it rationally. And so here, in terms of ejectment, if somebody's not physically there to prevent them and the person in the apartment is still willing to let them in, I don't know how we protect the other people in the building. I guess then you have to initiate eviction procedures for the person who's allowing the person who's forbidden to be there in, I guess.
So, the sort of circumstance we're talking about involves a level of sort of threat or coercion to the tenant, and I think creating the automatic no trespass creates a legal protection for the tenant and others in the building to just call the police and have them removed. So I do like Senator Hashim's idea of having this procedure result in kind of an immediate no trespass.
Yeah.
Judge?
Tom Zoney, Chief Superior Judge, I have been listening to the discussions, and I think that when we were talking yesterday, Michelle and myself, the idea of there's two things. There's the landlord-tenant obligation, and then there's these people who are coming in and who are not on the lease. They may be there with the tenant, and the tenant may be saying, sure, great, stay here. But there may also be circumstances, it appears, where they're basically, the tenant might even leave and there's still these people there who were just in the property dealing drugs or whatever they may be doing. The idea that you can get a quick hearing, right now we have this 4853B that we mentioned before, does provide a protection against someone subleasing if that's prohibited by a written lease. That provides one level of protection, but it doesn't address the circumstance where someone says, well, I'm not a sublease, lessee, I'm just here because they're letting me stay here. And I think that's where we do the ability of law enforcement and coordination with the state's attorneys would be important, because there is the ability to say, you're not allowed here. If someone is caught drug dealing in a location, in an apartment building, and they go to court, the attorney can get notice from the landlord saying, look, we don't want them back on our property. And not only can the landlord, if they're not a tenant, give them a notice against trespass for coming on the property, the public areas and the property, but the state's attorney can also request the judge to get a condition of release saying, don't go there. And if the court issues a condition of release saying that you may not go to building A, and you go to building A, that's a crime. And you can be arrested by law enforcement, and then that's a new charge. And then the court would address what the next steps are. But there is the potential for the criminal side of things if someone is charged with a crime to impose potential conditions. And that, I think, is important for the state's attorneys to coordinate. I know that there's the potential, some thought can also be given to, well, maybe the state's attorneys would have the ability to go in. I don't know how smoothly that would work, but I do know that there is the ability of the state's attorneys to have, and law enforcement to have, a vital role in, once someone is identified and removed from the property and that goes to court, there are conditions that can be entered. And if there is a procedure that the legislature that you were to adopt that speeds things up or allows the process to go forward, you could put in there that if you're removed from here, the order that is served on the person says you can't go back on the property, as Senator Hashim said.
That sounds reasonable.
And then we're back to.
I think the landlord may be afraid in many cases to try to take action.
Well, so I did have some discussions. I had discussions with some colleagues on that. And that is the sense, because what I understand is happening in the courts at times is that you may have individuals engaging in behavior. And we heard last week at the joint Senate committee meeting that I think once the gentleman talked so much as people would actually come in and physically hit somebody and say, I'm going in anyway. People, if they're afraid, aren't going to want to come to court to testify, I understand, based upon criminal activity or other activity, because they're living in fear. And that's what I understand. And other tenants may be afraid to come in too. And so I understand that has been an impediment to addressing these issues, because if it comes to court, whether it's illegal activity or criminal activity, whatever it may be, the landlord still has to prove it. And I am aware that at times landlords will come in and say, well, there's a lot of people coming in and out of the property, so they must be dealing drugs. And someone told me, or I was told, that they were dealing drugs. And hearsay is not admissible. So it puts the landlord in the position of essentially prosecuting a drug case. And they oftentimes don't have the witnesses to do that, because people have a right to Fifth Amendment. People may not want to talk. What if law enforcement is in the middle of a significant investigation and they want to call the Burlington police officer to testify about what he or she knows, and that could jeopardize the investigation? So there's a lot of complex issues that can tie in when a proof issue comes up for the criminal activity, illegal activity type actions.
Senator.
Judge, regarding the notice of ejectment, does the person who is not the leaseholder, are there any notices or anything that they have to be served before the notice of ejectment?
It depends. If you know someone is living there as a tenant, in foreclosures, for instance, the plaintiff's counsel will always put in any occupants of and try to serve them. And so oftentimes attorneys will put in the occupants just to avoid any legal issues there. There are some who would say, no, there's no notice. They're not on the lease. We don't know who they are. There are others who would say, well, belt and suspenders, you want to notify everyone there about having to leave.
And these notices that are served, they're done by just sheriff deputies, or are there other entities that do this as well?
I think some counties constables may serve it in some areas, but predominantly I believe it's sheriff's deputies.
Thank you. And just as a general comment for the committee, one of the issues that I've heard about a lot during the off session has to do with the time in which these notices are served. And, I think this is something worth discussing with the sheriffs, because the complaints that I've heard from landlords is that these notices whether it's a notice of termination or ejectment, they're taking a very long time to get served. And then there are certain, I guess, timers that are, that have to get reset because they haven't been served during a certain time frame, which is just prolonging the process. So it might be worthwhile to hear from.
Yeah, let's let Tim Waddon Dumont, who represents the sheriffs as well as the state's attorneys now. And maybe Sheriff Anderson could speak to it. I think he's still the president of the sheriff's association. So for next week, and Ben is busy handing out, he'll probably hear me. If the next week we could hear from Sheriff Anderson and Tim Dumont regarding what Senator Sheen just brought up about timelines for sheriffs. You want this done quickly because you don't want to wait.
Yeah.
Anyway, and John Gray is here, who's the ledge counsel for this section of the bill.
Well, I don't want to put John on the spot. I just want to say, I just invited John in here because he had been in part of the conversation with Judge Zone and I yesterday. And so what I did just for getting the ball rolling is I just stuck in section 3 here. There's no changes to 4853B, but it's the, I wanted you to be able to see the language that Judge Zone is talking about. And then if there's any suggested changes to that, then
Well,
I think on the next version.
The changes to make it a flash site. What do you call those things?
Oh, if someone
Makes
goes
it-
to court immediately, flashlight, that's correct.
Yeah, right, yeah,
Flash site,
something like that. I think that's what it's called.
Flashlight,
That is,
flashlight,
Flash site.
is
Site.
site CIP?
yes, like
Yes,
citation.
CIP, flash citation, so it's immediate action.
Got it, okay.
It did sound like flashlight.
Judge Zone, I'll circle back around with you on language for that.
that works.
But just to note for those in the committee, there's a section missing. And I asked Michelle to take out the 3-year mandatory minimum for sale of fentanyl.
Now, there's a 2-year minimum,
For death result.
yeah.
We can discuss section, we never really discussed sections. What was section 3 is now section 2. Section 3 is gone because the 30-year maximum is current law.
Mm-hmm.
And it was only the 3-year minimum that was part of section, the original section. So I thought after we heard testimony from a number of witnesses, that was probably a section that we wouldn't support, so.
Also, in section 1, I did change the definition of fentanyl from the one that was introduced to the language that was offered by the state's attorneys.
Yep,
So there's some small changes there to that definition. But those are the only changes other than
and
what
then
Senator Sears
at
mentioned.
10:15, we're gonna hear from the health department regarding xylazine and how to deal with that. So, anyway, Senator Sheen.
So we're keeping, I'm sorry, can we, regarding this 2-year minimum, is that,
It's gone.
okay, so that is, all right, just wanted to make sure.
That was section 2 of the original bill.
And so we're going to make it so that there's no
Right.
mandatory minimums
Right.
in this.
No
So you want the
mandatory
mandatory
minimum.
minimum out on section 2 on death resulting?
That's what, I don't know, we haven't even discussed that.
Okay.
Oh,
So I think we have to have a discussion.
Yeah.
Whether or not that should stay. I think there's some interest in that because you have a death result. That, we can discuss that as a committee. We never really got to that section.
Are y'all done talking about the property issues or?
I think so, I think we need to get new language next week.
Okay, and the only change for all of that stuff is on the flash citation?
Well, the flash citation, but also,
You'll get
does that allow the
testimony on
state's
service.
attorney to take the action?
No, it's the way that the
I want
statute
the
is,
action to be able to be commenced by the state's attorney. You know, let's say landlord never complains. Some of the landlords are scared to death. And the landlord never says anything. the police know what's going on. They should be able to go to the state's attorney and have that person removed. You know, I take my example, and it's a real one from Bennington. The woman allows them to come in. They set up shop in her apartment. They give her drugs. Then later on, she'd like to get rid of them. They refuse to leave, and then use her in human trafficking for sexual acts. Then they still refuse to leave, but nobody can get rid of them. And they're not leaseholders, they're not part of that system, and I want the state's attorney or police to be able, the state's attorney to be able to initiate the action.
Okay, so it would be, expand it to allow state's attorneys, not just the landlord's
Right.
agent or the tenant.
Because the landlord may be scared, the
Right.
tenant may be scared.
Right, and then also expand it beyond people who are like subletters, so it could be like somebody who's not connected at all,
Right.
and then you want a flash citation.
Yep. They, you know, my example is they got the gun on the table and they ain't leaving.
Can I add something just to, because I know you want to make this complicated, right? So, I'm just kidding. The other, there's also another piece that might be helpful, and I was talking with the, I believe it was the Civil Procedure Committee, the Rulemaking Committee, regarding who can serve process for notice of termination. And, you know, right now, I believe it requires, or it allows only sheriff deputies, constables, or people specially appointed by the court. The rule proposition, or the proposed change is to allow private individuals to also serve notices of termination. This is something that a lot of other states do. They have private businesses that are essentially delivery people for process. And there is language on that. Yeah.
Eric did a
Yes,
bill, is it
yeah.
in here?
It is, yes.
Do you know the number?
Not off the top of my head, but I can get that to you during the break. and
Okay, do
figure
you
it out.
wanna see about pulling that into on the next draft, Senator Sears? Like
Yep.
the-
It might be helpful for this whole
Okay,
thing, so.
But just to clarify a little bit here, it's not deputies and or sheriffs that do this. Okay, we have what's referred to as process servers, civil process servers. John Q, civilian, no law enforcement, simply give them an ID. I had 3 of them, I think, okay? And they would go out and serve all these civil processes you're talking about. The only thing that the sheriff would actually, or the deputy would actually serve and the sheriff would execute is an actual writ of possession. The constables can go out and serve this stuff, but by statute, the only one who can actually take action on this is the sheriff. So they used to have constables, whatever, do the writs, serve them, and then they contact me and say, oh, well, we need you to come do the execution on one. That's not the way it works, okay? I've got no copy of the execution. It goes to the sheriff's office, basically. There's a carbon copy, so that you'll get one as the person who requested it. I'll have one for the records so that we know it's, and I'll go with the courts. They have it also. It's not, and everybody works within, I'll let Mark explain, Sheriff Anderson explain. Everyone works within basically a 7-day period. Okay, it's because you gotta try an attempt during the day, an attempt at night, and an attempt on the weekend. Because during the day, some people work Monday through Friday. So it was always an attempt. So within a 7-day period, and what would happen is we'd make 3 attempts, call back the individual who wanted to serve, say, listen, okay, we know that you've paid for 3 attempts. We've exhausted that. If you want us to continue, we will. Well, most of the time we catch them within that 7-day period.
But it also comes with an automatic no trespass order.
When you're getting the notice of ejectment.
Yep.
The judge also is issuing a no trespass at the same time.
The proposed
We have to
language I have in the
assume-
rule
We have to assume the
doesn't change the
landlord
writ of ejectment.
or the
Writ of
tenant
Sheriff
possession.
serving, just the written
are
notice
afraid
of
of the
termination.
drug dealer.
The invitation to
I think that was Judge Zoning.
14-day
Yeah,
invitation.
which you have to do.
You have to do.
So,
Anybody can do that.
I've heard differently, but, I mean, if that's the case, then that's awesome.
The landlord can do that.
Girl,
What?
The landlord can do that.
I have no sympathy.
I've heard differently though, and but if that's the case, then
They're preying on
landlords,
weaknesses of individuals.
Maybe there
Terrorizing
needs some
apartment buildings. Houses.
clarification in the rule language then.
Man, I heard a lot
The
of
more
that.
confusing we can make it, the better it will be, so.
So why don't we take a 10-minute break and get back at 10:15, please? And then we'll hear from the Department of Health